Good afternoon, all. Thank you for joining me on In Focus with Silvana Pavlovska. I hope you're having a good day. Today, we're going to continue with Chapter 4 of the Prespa Agreement as cultural genocide of the Macedonian national identity towards the termination of an illegal treaty by Professor Dr. Igor Yanev. This book was published in 2023. And we are on Chapter 3.3. The Prespa Agreement and the existing norms of international law and principles covering the rights of a state. In the preamble of the Vienna Convention on the Law of Treaties, 1969, it is stipulated that the state parties of the convention are, in quotation, having in mind the principles of international law embodied in the Charter of United Nations, such as the principles of equal rights and self-determination of peoples, the sovereign equality and independence of states, of non-interference in the domestic affairs, and of universal respect for and observance of human rights and fundamental freedoms for all. In the preamble of the Prespa Agreement, it is also stipulated that the parties of the agreement are, quotation, guided by the spirit and principles of democracy, respect for human rights and fundamental freedoms and dignity, and abiding by the provisions of the Charter of the United Nations. However, already in the first sentence of the preamble of the Prespa Agreement, the parties of the agreement are treated as unequal. The first party is identified by its constitutional name, that is, Hellenic Republic, while the second party is identified as the state, in quotation, which has admitted or was admitted to the UN in accordance with the UN's General Assembly Resolution 47/225 of the 8th of April 1993. End of quotation. This unequal representation of the treaty parties already in the treaty preamble is a violation of the principle of sovereign equality of states and non-observance of the dignity of the second party. This unequal position of the parties remains throughout the text of the treaty. The Prespa Treaty contains 3 parts, of which only the first part, containing 8 articles, deals with the name issue. The other 2 regulate matters of bilateral character, such as economic, political, and cultural relations, and the establishment of a, quotation, strategic partnership. In paragraph 2 of Article 1, quotation, the parties recognize as binding the outcome of the negotiations that have taken place under the auspices of the United Nations, to which both parties have been committed pursuant to the United Nations Security Council Resolution 817 of 1993 and 845 of 1993, as well as the Interim Accord of 1995. We note that the Security Council Resolution 845 of 1993, quotation, urges the parties to continue their efforts to arrive at a speedy settlement of the remaining issues between them, end of quote. The wording, in quotes, remaining issues, in the interpretation of the first party of the Prespa Agreement, does not mean only, in quotation, differences over the name, but extends to matters of national identity, state, national language, constitution, and even the internal administrative systems and regulations. This Greek interpretation of the provisions of the Security Council Resolution 845 of 1993 is fully arbitrary and goes far beyond the original scope of the negotiations for, quotation, settlement of differences over the name, end of quote, as defined by the Security Council Resolution 817, 1993, and the General Assembly 47/225 of 1993, which, as already discussed earlier, violate the United Nations Charter. Even from the title of the Prespa Agreement, we note that it regulates differences, plural, not just settlement of a difference, as provided by the Security Council Resolution 817. Nevertheless, this Greek erroneous interpretation of the Security Council Resolutions 817 of 1993 and 845 of 1993 is thoroughly reflected in 8 articles of Part A of the Prespa Agreement. All 8 articles of Part A of the Prespa Agreement. The tone and the wording of the provisions of this part of the agreement are reminiscent of those of a peace treaty dictated by the party winning the war to the one that had lost the war. This can be illustrated by the text of paragraph 3 of Article 1 of the agreement, where the treaty obligations of the second party are enumerated. 3, quotation. Pursuant to those negotiations, the following have been mutually accepted and agreed. A. The official name of the second party shall be the Republic of North Macedonia, which shall be the constitutional name of the second party and shall be used erga omnes as provided for in this agreement. The short name of the second party shall be North Macedonia. B. The nationality of the second party shall be Macedonian citizen of the Republic of North Macedonia, as it will be registered in all travel documents. C. The official language of the second party shall be, quotation, Macedonian language, as recognized by the Third UN Conference on the Standardization of Geographical Names held in Athens in 1977 and described in Article 7, Paragraph 3 and Article 4 of this agreement. D. The terms, in quotation, Macedonia, end of quotation, and quotation, Macedonian, end of quotation, have the meaning given under Article 1, Paragraph 7 of this agreement. E. The country codes for license plates of the second party shall be NM or NMK. For all other purposes, country codes remain MK and MKD as officially assigned by the International Organization for Standardization, or ISO for short. F. The adjectival reference to the state, its official organs, and other public entities shall be in line with the official name of the second party or its short name, that is, quotation, of the Republic of North Macedonia, end of quotation, or, quotation, of North Macedonia, end of quotation. Other adjectival usages, including those referring to private entities and actors that are not related to the state and public entities, are not established by law and do not enjoy financial support from the state for activities abroad, may be in line with Article 7, Paragraph 3 and Article 4. The adjectival usage for activities may be in line with Article 1, Paragraph 7, Article 3, and Article 4. This is without prejudice to the process established under Article 1, Paragraph 3H, and compound names of cities that exist at the date of the signature of this agreement. G. The second party shall adopt, quotation, Republic of North Macedonia, end of quotation, as its official name and the terminologies referred to in Article 1, Paragraph 3, through its internal procedure that is both binding and irrevocable, entailing the amendment of the Constitution as agreed in this agreement. H. In relation to the above-mentioned name and terminologies in commercial names, trademarks, and brand names, the parties agreed to support and encourage their business communities to institutionalize a sincere, structured, and in good faith dialogue in the context of which we seek and reach mutually accepted solutions on the issues deriving from the commercial names, the trademarks, the brand names, and all relevant matters at bilateral and international level. For the implementation of the above-mentioned provisions, an international group of experts will be established consisting of representatives of the two states in the context of the European Union, EU, with the appropriate contribution of the United Nations and the ISO. This group of experts shall be established within 2019 and conclude its work within 3 years. Nothing in Article 1, Paragraph 3H shall affect present commercial usage until mutual agreement is reached as provided in this subsection. It is obvious from the above, says Professor Dr. Igor Yarnev, that the first party essentially dictates the treaty provisions, while the second party needs only to accept them. The inequality of treaty parties is obvious despite of their equal legal status under the international law. The second party obviously has a subordinate position with respect to the first one. The core provisions B and C of paragraph 3, which we've read a few minutes ago, are essentially beyond the scope of the subject of the agreement defined by the Security Council Resolution 817, in brackets, quotation, settlement of difference, end of quote, over the name, and relate to the matters of national identity and language. As mentioned in subparagraph 3F above, the meaning of the noun, quotation, Macedonia, end of quotation, and the adjective, quotation, Macedonian, end of quotation, is provided by the provisions of Article 7, the first 3 paragraphs of which read as follows. 1. The parties acknowledge that their respective understanding of the terms Macedonia and Macedonian refers to a different historical context and cultural heritage. 2. When reference is made to the first party, these terms denote not only the area and people of the northern region of the first party, but also their attributes, as well as the Hellenic civilization, history, culture, and heritage of that region from antiquity to present day. 3. When reference is made to the second party, these terms denote its territory, language, people, and their attributes with their own history, culture, and heritage distinctly different from those referred to under Article 7, Paragraph 2. The provisions 2 and 3 deprive the terms Macedonia and Macedonian from their general meaning, framing them within a historic, cultural, or regional context. This is a severe derogation of Macedonian national identity and the Macedonian language. It represents a flagrant negation of the rights to national collective identity, national culture and language of Macedonian minority in Greece and other countries. Like the state name, the identity of a people, its culture and language are indivisible, non-transferable, and non-alienable, says Professor Igor Yanev in his scholarly paper, The Prespa Agreement as a Cultural Genocide of the Macedonian National Identity Towards the Termination of an Illegal Treaty, published in Belgrade in 2023. And today, in this live broadcast, we are sharing with you Chapter 3, what is the remaining of Chapter 3. And I wish to remind you that this document, this publication, contains 6 chapters, as well as other documents, which shall also be sharing with you. And at this moment, I also wish to thank Professor Dr. Igor Yanev for giving us the permission to be able to make this document available to you publicly. Your comments, your questions are welcome. We should be happy to pass them on to Professor Igor Yanev. Continuing on with Chapter 3.3, and I'll just remind ourselves with the last sentence. The provisions 2 and 3 deprive the terms Macedonia and Macedonian from their general meaning, framing them with a historic, cultural, or regional context. This is a severe derogation of Macedonian national identity and the Macedonian language. It represents a flagrant negation of the rights to national collective identity, national culture and language of the Macedonian minority in Greece and the other countries. Like the state name, the identity of a people, its culture and language are indivisible, non-transferable, and non-alienable. Therefore, says Professor Igor Yanev, the Articles 1, paragraph 3F, and Article 7 are in violation with the general terms of the international law, including those related to the rights of minorities. In the remaining paragraphs 14 to 30, in the remaining paragraphs 4 to 13 of Article 1, the implementation of the provisions of Article 1, paragraph 3 are stipulated again in an ultimate form, with the first party playing the oversighting role. Number 4, upon signing the agreement, the parties shall take the following steps. A, the second party shall, second party being Macedonia, shall without delay submit this agreement to its parliament for ratification. Goodness me. It's like an order. B, following ratification of this agreement by the parliament of the second party shall notify the first party that its parliament has ratified the agreement. Another order. C, the second party, that's me saying another order. It sounds like an order, it's another order. Silvana Pavlovska adding that, it's not in the document, so just clarifying matters. C, the second party, if it decides so, will hold a referendum. So if the second party, that is Macedonia, decides so, it will have a referendum. So it's up to their discretion, in other words. D, the second party shall commence the process of constitution. Now that's a spelling error. I shall read that again. D, the second party shall commence the process of constitutional amendments as provided for in this agreement. E, the second party should conclude in toto the constitutional amendments by the end of 2018. F, upon notification by the second party of the completion of the above-mentioned constitutional amendments and of all its internal legal procedures for the entry into force of this agreement, the first party should promptly ratify this agreement. Now, Silvana Pavlovska, journalist, independent speaking now. Has the first party ratified this agreement? Has it? Has it been ratified? What's the legal status? What is the position? What's the treaty status? Have they ratified the agreement? My understanding is they haven't. Let's continue. 2, number 5. Upon entry into force of this agreement, the parties shall use the name and terminologies of Article 1, Paragraph 3 in all relevant international, multilateral, and regional organizations, institutions, and fora, including all meetings and correspondence, and in all their bilateral relations with all member states of the United Nations. 6. In particular, immediately upon entry into force of this agreement, the second party shall. See, it sounds to me like a very one-sided agreement, don't you think? So 8, in particular, immediately upon entry into force of this agreement, the second party shall, A, notify all international, multilateral, and regional organizations, institutions, and fora of which it is a member of the entry into force of this agreement, and request that all these organizations, institutions, and fora thereafter shall adopt and use the name and terminologies referred to in Article 1, Paragraph 3 of this agreement for all usages and purposes. Both parties shall also refer to the second party in accordance with Article 1, Paragraph 3 in all communications to, with, and in those organizations, institutions, and fora. Definitely dictatorial. This is not an agreement. Silvana adding a comment here. B, notify all member states of the United Nations of the entry into force of this agreement and shall request them to adopt and use the name and terminologies referred to in Article 1, Paragraph 3 of this agreement for all usages and purposes, including in all their bilateral relations and communications. Fait accompli by the sound of things. Number 7. Upon entry into force of this agreement and subject to provisions under Articles 1, Paragraph 9 and Paragraph 10, the terms Macedonia, Republic of Macedonia, FYR of Macedonia, FYR Macedonia, in a translated or untranslated form, as well as the provisional name, the former Yugoslav Republic of Macedonia, and the acronym FYROM shall cease to be used to refer to the second party in any official context. 8. Upon entry into force of this agreement and taking into account this Article 1, Paragraph 9 and Paragraph 10, the parties shall use the name and terminologies of Article 1, Paragraph 3 for all usages and all purposes erga omnes, that is domestically in all their bilateral relations and in all regional and international organizations and institutions. 9. Upon entry into force of this agreement, the second party shall promptly, in accordance with sound administrative practice, take all necessary measures so as to the country's competent authorities henceforth use internally the name and terminologies of Article 1, Paragraph 3 of this agreement in all new official documentation, correspondence, and relevant materials. Sounds to me it was written by the Hellenic Republic. Yeah, solely, and imposed on the Macedonian Republic. 10. As regards the validity of already existing documents and materials issued by the authorities of the second party, the parties agreed that there shall be 2 transitional periods, one technical and one political. Really? A. The technical transitional period shall relate to all official documents and materials of the public administration of the second party for international usage and to those for internal usage that may be used externally. These documents and materials shall be renewed in accordance with the name and terminologies as referred to in Article 1, Paragraph 3 of this agreement within 5 years from the entry into force of this agreement at the latest. Has the Greek parliament ratified the agreement? Is the agreement valid? If it's not ratified, my knowledge and understanding is that it hasn't been ratified by the Hellenic Republic. B. The political transitional period shall relate to all documents and materials exclusively for internal usage on the second party. The issuance of the documents and materials falling under this category in accordance with Article 1, Paragraph 3 shall commence at the opening of each EU negotiation chapter in the relevant field and shall be finalized within 5 years thereof. A deadline. 11. procedures for the prompt amendment of the Constitution of the second party in order to fully implement the provisions of this agreement shall commence upon ratification of this agreement by its parliament or following a referendum if the second party decides to hold one. Really? Isn't the second party capable of deciding what they want to do, whether they want a referendum? Do they need to be told that it's at their discretion that they can have one? My question to you. Number 12, the name and terminologies as referred to in Article 1 of this agreement shall be incorporated in the constitution of the second party. Wow. The change shall take place en bloc with one amendment. Pursuant to this amendment, the name and terminologies will change accordingly in all articles of the Constitution. Furthermore, the second party shall proceed to the appropriate amendments of its preamble. Article 3 and Article 49 during the procedure of the revision of the Constitution. Shall read that one again. Furthermore, the second party shall proceed to the appropriate amendments of its preamble, Article 3 and Article 49, during the procedure of the revision of the Constitution. 13. In the event of mistakes, errors, omissions in the proper reference of the name, and terminologies referred to in Article 1, Paragraph 3 of this agreement, in the context of international, multilateral, and regional organizations, institutions, correspondence, meetings, and fora, as well as in all bilateral relations of the second party with its third states and entities, either of the parties may request their immediate ratification or rectification, I beg your pardon, and the avoidance of similar mistakes in the future. Sounds to me the whole agreement is a mistake and error. It should be noted that the implementation of the provisions of Article 1, Paragraph 3 requires amendments of the Constitution of the second party. Paragraph 4, D and E. Then we've got Article 11 and Article 12, and the use of the new name, and related terminologies shall be used for all purposes erga omnes, internally and externally, by both parties. Article 1, Paragraph 8. A new name to an ancient country and peoples. Sounds like a theatrical performance whereby you can say anything, everything. Not the truth, is it? The provisions of Article 3, Paragraph 3, I beg your pardon. The provisions of Article 1, Paragraph 3, A, B, and C, related to the name, national identity, and the language, respectively, of the second party, and the provisions of Article 7, paragraphs 1 to 5, providing historic, territorial, and cultural restrictions to their use, and thereby severely derogating their meaning, as well the provisions of Articles 1, Paragraph 4, Article 1, Paragraph 11, and Article 1, Paragraph 12, imposing explicitly revision and amendments to the Constitution of the second party, are obviously in conflict with the peremptory norms of international law and Article 53 of the Vienna Convention on the Law of Treaties from 1969. For this reason, the Prespa Agreement can be considered as null and void and a subject of unilateral termination, says Professor Igor Yanev. As argued earlier, the state name and national identity are essential parts of an inalienable right of peoples to self-determination of peoples and nations, that is self-identification. Moreover, the national identity is by its nature an unchangeable inherent category. It is a self-identification of a group of people built through a common history, sharing the same language, customs, beliefs, ethical norms, and having the same aspirations. It is a social phenomenon existing essentially outside of the realm of the law. The main psychological characteristic of the members, such as a social group, is their individual and collective consciousness of their belonging to the group. Therefore, both the national identity and the name of the state per se cannot be subject to negotiation or imposition. The population of Macedonian nation on the territory of present Macedonia has been carrying that name and national sentiment for centuries, politically expressed during the long struggle for independence from the Ottoman rule and the occupation by the neighboring Balkan states, finally achieving its statehood at the first session of ASNOM, the Anti-Fascist Assembly for National Liberation of Macedonia, on September 2nd, 1944. The national self-determination of the Macedonian people with the Macedonian language as state language were proclaimed at ASNOM and reaffirmed in the first constitution of 1946 of the People's Republic of Macedonia as constitutive unit of the Federal People's Republic of Yugoslavia, as well as in the constitutions of the Socialist Republic of Macedonia from 1963, constitutive unit of the Socialist Federative Republic of Yugoslavia, SFRY, and of Independent Republic of Macedonia, 1991, after the dissolution of the Socialist Federal Republic of Yugoslavia. Perhaps the most unusual and apparently outside the legal framework of international law is the establishment by the Article 8, paragraph 5 of the Prespa Agreement. Quotation, on a parity basis, a joint interdisciplinary committee of experts on historic, archaeological, and educational matters to consider the objective scientific interpretation of historical events based on authentic, evidence-based, and scientifically sound historical sources and archaeological findings. The committee's work shall be supervised by the ministries of foreign affairs of the parties in cooperation with other competent national authorities. It shall consider and, if it deems appropriate, revise any school textbooks. Where were we? It shall consider and, if it deems appropriate, revise and any school textbooks and school auxiliary materials such as maps, historical atlases, teaching guides in use in each of the parties in accordance with the principles and aims of UNESCO and the Council of Europe. To that effect, the committee shall set specific timetables so as to ensure in each of the parties that no school textbooks or school ancillary material in use the year after the signing of this agreement contains any irredentist, revisionist references. The committee shall also study any new editions of school textbooks and school auxiliary material as provided for under the article. The committee shall convene regularly, at least twice a year, and shall submit an annual report on its activities and recommendations to be approved by the High-Level Cooperation Council as to be established pursuant to Article 12. Who is the High-Level Cooperation Council? Who is in there? Who's appointed them? This provision is far from the legal standards of sovereign rights of states, provides an illegal mechanism for revision of the cultural history of the second party and permanent intervention and control of its cultural and educational policies, hence severely derogating its sovereign cultural human rights and sovereign identity. The mentioned principle relating to collective human rights as a rule of self-determination is also applicable to the to the basic rights of states as nation states. Namely, states have a right to self-determination, particularly to self-identification and judicial equality vis-a-vis other sovereign states or nations. A link between the name of the state and a general category of a national identity as a collective international human right lies in the category of legitimacy, that means original sovereign people's will and consent to freely refer to itself and to self-identity, itself or themselves, as a people or as a nation, in accordance with the basic principle of sovereign people's will, that is, principle of a popular sovereignty. The creation of the above-mentioned mechanism, as we will demonstrate in the next chapter, that is chapter 4, provides for imposed cultural redefinitions and deletion of historical memory to the magnitude of cultural genocide or ethnocide. Such impositions, creating irregular bans and restrictions on choice, collective, popular, individual, are possible to be performed only in the society ruled by an autocratic system of government, characterized by features far from the accepted definitions of democratic standards. Beside the observed legal deficiencies and lawlessness with respect to text of the Prespa Agreement, there should also be noted that Macedonia was under strong foreign pressure to accept that undoubtedly illegal act. We should remind you at this point that the treaties made under coercion or threat to use the force or by blackmailing may also be treated as invalid acts. In the case of Macedonia, those external pressures to accept the act was coupled with promises for reaching a date for opening the EU-Macedonian negotiations for accession to EU membership. For example, promises by Angela Merkel and others. These promises, after the process was completed regarding the entrance into force of the Prespa Agreement, were never carried out or fulfilled. In fact, it seems that in order to reach the compromise with Greece, the Macedonian government was blackmailed by Greece, the United States and the European Union, and under pressure effected all demands in that irrational process, including the registration of the Prespa Agreement in the UN Secretariat Registry. Undoubtedly, Macedonia took too seriously empty promises by the EU leaders and diplomats for guaranteed future of the Republic of North Macedonia in the European Union. The attitude of the phony promises, I would say the lies, the deceitful communications, the attitude of the phony promises on one state and potential threats on the other, coupled with irrational or illegal subject matter of the agreement itself, are reminiscent to colonial or neo-colonial attitude and policy already seen in the history of international relations, particularly in the cases of the indigenous people under colonial rule worldwide. Essentially, the Prespa Treaty nullified the existence of the Macedonian minority in Greece and erga omnes elsewhere as well, including Australia, America, wherever the Macedonian people are. That nullification was based on the grounds of non-existence of their national identity in Greece, but also everywhere globally. From the legal point of view, says Professor Igorianev, if a national state abolished national identity on a universal scale, essentially supporting that it does not exist, that would entail non-existence of such identity at all, including domestically. That aspect was entirely unknown both for government and oppositional parties. In addition, we may remind you that a duty to take care, or a duty of care, of own national minority abroad is a part of international law, and that each country has international obligations with respect to that. Therefore, it appears as a consequence that with self-denial policy, the Macedonian government, with the conclusion of the treaty, violated international norms with respect to the protection of the minority rights. And so we end chapter 3 of the scholarly paper, The Prespa Agreement as Cultural Genocide of the Macedonian National Identity Towards the Termination of an Illegal Treaty, a publication published in 2023 by Professor Igor Yanev, an eminent scholar, professor, expert on international law and constitutional law. He has published many books, and you are most welcome to check him out or do your research on the internet and find out more about Professor Igor Yanev. I shall not be making any comments about this chapter. I've already done so on a few occasions. I think that should be it for the day. I thank you for your attention. We shall continue next time with chapter 4 for more revealing information. For more revealing information. So please stay tuned. It's most likely going to be either tomorrow, which is the 29th of February, today being 28th of February. So most likely tomorrow, if not tomorrow, then definitely it'll be on the 1st of March, 2024. Once again, thank you for joining me today in Focus with Silvana Pavlovska. I'm looking forward to seeing you soon. Bye for now.